Hey, Ben? Ben?
Yes. We're live. Everyone can hear us right now.
Okay, so there's some folks saying that they can't hear anything, so...
Because we're not talking.
They should be hearing something. Okay, now they're saying they got it. Okay, thanks, everybody. I wasn't... Okay, so if you can hear me over the speakers on your computer, then you don't need to be dialing in. We only have the capacity for 150 people to hear us via the phone. The response to this was so overwhelming that we upgraded the software so that you could hear the audio through your computer speakers. But there's still a few folks out there that don't have computer speakers, so we have 150 line capacity for folks to call in. So if you can hear us over your computer, hang up the phone. You don't have to listen from both places. And then folks who need to use the phone line, there'll be more capacity for them to do that. So we've got 735 people signed on so far. We had 3,000 people register for this. So with that kind of interest, CRPA, NRA, and GOC are happy to put together these type of webinars on pretty much just about any subject that there's a broad-based interest in, and it doesn't have to be anywhere near 3,000 people. If there's 50 people who have a question about something, we'll do one of these for that small of an audience. It doesn't take that much, and frankly, we get so many questions. NRA, CRPA, GOC, my law office, we're just flooded with questions, phone calls from people asking questions about these laws and all the old laws. And so it's much easier for us to answer those questions on a big call like this to a whole bunch of folks at one time rather than trying to do it individually to individual phone callers. Ben, I'm not sure if there's a way to turn up our broadcast volume. Some folks are saying their computer volume is turned up all the way and they have a hard time hearing us.
The audio has been turned up as high as we can go. So I would suggest at least turning up the audio on your own computer. If that's the highest it can go, then we can try to speak louder or closer to the phone.
Yeah, I'll go off speaker. Thanks, everybody, for your feedback. Yeah, I was on a speakerphone, so now I've picked up the handset. That should make me easier to hear.
So it is 12:05. Did you want to start, Chuck?
Yeah, let's roll. Let's roll. Yes. So you want to take us in, Ben, and then.
Okay. So my name is Ben Machida. I'm an attorney here at Michelle & Associates. And I guess if you guys want to present yourselves, you and Chuck, or Chuck and Joe.
This is Chuck Michelle. I'm the senior partner at Michelle & Associates. Our law firm has had the pleasure and privilege for the last over 20 years to represent the NRA and the CRPA in California. I guess that's about all I need to say for the moment. Joe.
And hi, everybody. This is Joe Slavosa. I'm an attorney here, also like Ben at Michelle & Associates. I've been here going on 10 years next month. Thanks for anybody who has attended any of my previous gun classes for gun owners and CLEs or heard us on Firing Line Radio Show with Phil Naiman or anywhere else. And I guess my wife's response would be, why would you guys come back for more? But nevertheless, thank you all for that. I'm in charge of regulatory compliance with Michelle and Associates. We've advised some of the largest manufacturers and dealers of firearms throughout the country on the ins and outs of California gun law. I also handle the firm's criminal cases, and part of the reason why we do stuff like this is to make sure you're not contacting our office with a criminal case and having the unfortunate displeasure of having to speak to me concerning rather serious issues. And so we'll be talking about some very serious issues today, and hopefully keeping you guys from having to make that phone call in the years to come about being charged with potentially assault weapon or having made your own firearm and failing to register it. I see a lot of people with their hands raised. Keep in mind, I think Chuck might have mentioned it already about the next slide that we already had up before, discusses how we'll address the questions. Please feel free, and thank you for whoever advanced that for me, throw those questions into the chat. We will be combing through all of those questions and then combining them. There are often a lot of duplicate questions. We'll be putting those together and then putting out an answer for the frequently asked questions from this chat. So I appreciate the hands being raised and the questions that we'll present. Ben, whose voice you heard at the start of this, you might be able to kind of cull through some of those and ask them as we go along. But the vast majority of questions, heck, I'd probably be here answering questions until 5 o'clock tonight if we had tried to address them all. And I got a lot of other work I need to do. But nevertheless, we will go over all of those and, like I said, get answers out to you. And signing up, you should have submitted an email address. We hope to be able to send them out to you, or in the alternative, with the CRPA. And so thanks for all the questions. We appreciate them. We will not be able to address all of them for all you all because we've got now 837 people in the room. We're not going to be able to address all those questions today.
So let me just sort of introduce us here on this first slide. Today we're going to be talking about the so-called assault weapon bill modifications and the ghost gun, so-called ghost gun bill. We will be doing future webinars on the other bills that were signed by Governor Brown recently. I think we'll probably also do a future webinar on the Newsom initiative. We're planning one on the future of public carry in California. And again, as I said, any other topic that there's enough interest in, we'll be happy to do a webinar to help people get informed. What NRA, CRPA, and GOC are all trying to do is get gun owners informed and engaged so they know what it is that the status politicians in Sacramento are plotting to do to their gun rights, and hopefully vote. So I will say, though, that the presentation we're going to put on today is not a comprehensive, you just can't cover all the nuances of both, even though we're just doing it on these two specific bills for this particular webinar. You can't cover everything that those bills might or might not do and how they might be interpreted by courts or by the DOJ as a regulatory agency charged with interpreting to some degree some of these laws. So we started by trying to do a sort of a cheat sheet, a memorandum that we could distribute to everybody. That turned into a 66-page legal memorandum, which was way too dense to just be distributing to folks. So we came up with the idea of a webinar after we gave a webinar to a couple of hundred retailers, and they really seemed to like the format. That said, for those of you who want to get more information, know some of the background, really get into some of the nitty-gritty and the nuances of how these laws, these two that we're going to discuss today, plus all the others, plus all the laws that have existed, before this legislative session, the best way to do that, frankly, is to get my book. And I'm not trying to, this is not a money pitch here. We lose money on this book every year. But I would lose more money if I tried to answer every one of these questions separately because the staff time that used to take to do that. But the CRPA can make some money off it. And so what you can do now is order the 4th edition, which should be out right around Thanksgiving if all goes right, which often it doesn't, but as soon as possible. And we'll send you that 66-page memo, and then send you for free, and then send you the 4th edition of the book when it comes out. So if you're interested, contact CRPA. You can contact them at contact@crpa.org. Also, if there's a message that can get out, you have to put up with some commercials for a free webinar. If there's a message to get out to everybody listening and to ask you to get to all your friends, it's critical that we vote, not just in statewide elections, but in elections for state office, but also for local office. We're constantly looking for local races that we can have an influence on, and sometimes we can have a much bigger influence there. But even the local, the state level district races can be swayed by a couple of hundred votes. So your vote definitely matters, even though the Democrats, who we presume sometimes would vote against or would vote for gun control candidates, a lot of times they don't get out there. So it's all about the number of voters that get out and actually vote. You can register online, register to be a permanent by-mail voter, and you never even have to leave your house. You just mail it in. If you're interested in helping out CRPA, NRA, and GOC in being an activist in California, they need volunteers. You can volunteer to work in elections. You can volunteer to work at a gun show. You can volunteer to do pretty much anything you want to volunteer to do. We'd love to use your help. So general questions, send those to contact@crpa.org. Please don't send the gun questions. Please don't send. I'm trying to get as close to it as I can. People are saying they're having a hard time hearing me. I'm not sure what to do about that. But if you're interested in contributing to CRPA's magazine, tfl@crpa.org. Also, part of being an activist and being informed is getting plugged in. The California Connections, for a full list, go to crpa.org, California Connections, and they'll give you all the Facebook lists, Facebook pages, and everything else that all the websites, the subscription services that we have available, so that you can stay plugged in and informed about what's going on in California and have some influence on it. That's the big thing. We need everybody engaged. There are 8 to 12 million gun owners in the state of California. If we got 500,000 of them engaged, we'd control an awful lot of elections and things wouldn't be that bad. I think a lot of folks are sitting home with a gun in their nightside table and taking it for granted and don't realize exactly how carefully orchestrated and well-funded the campaign to. And I can say call it what it is. It's to end civilian gun ownership eventually, and that's not rhetoric or dogma. That's 20 years of watching and hearing what the gun ban lobbyists will say when we think nobody else is listening. That's what it's all about. So our tentative dates for the upcoming webinars. The next one I think a lot of people will have a lot of questions about is the ammunition background check bill. We're tentatively scheduling that for August 24th at noon. And then the lending, theft, loss reporting, and large standard cap magazines, misnamed large capacity magazine bills, would be the next week. So subscribe to those NRA alerts there, and you'll be kept up to date on when we have more webinars coming up. Okay, so Ben?
Yeah, so we have a couple of polls for you guys, so if you guys wouldn't mind answering them. The first one is, are you a member of any of the following organizations? So the National Rifle Association, CRPA, Gun Owners of California, or the Firearm Policy Coalition?
By the way, if you guys have suggestions for poll questions, this is a great way for us to gauge the concerns of members and gun owners about, what do you want the CRPA, the NRA, the GOC to be focusing on? Is there, an event you want done in your area, anything like that? We can do a lot of that. So we'll be using these kinds of polls throughout this webinar and future webinars to really kind of gauge where people are coming from on things.
Yep, so it looks like from this poll we have a lot of people here from the NRA. So we got one more poll. right after this. So, other than a membership, have you ever contributed to a pro-Second Amendment group for political purposes? So we got a lot of people who contribute, so that looks good. Alrighty, just wait for the rest of the responses here.
So, by the way, all of you guys and gals who are answering no, you're the people whose brains we want to pick and try and figure out why you don't and what we might do to motivate you to. So that's another reason why these polls are really helpful to us, because we can see that there's a significant number of people who don't donate, and it's probably, I could imagine, a combination of things, like you get too much junk mail from the NRA. That's a constant complaint, but there may be other reasons too. So if you have some thoughts on what it would take to get you interested enough to donate, we'd love to hear that at contact@crpa.org, and what we might change to get you to the point where you think it's worthwhile to donate, or to volunteer for that matter. So thank you, everybody, for your response to that one.
All right, so now let's throw it back over to Joe, who can start us off for today's stuff.
So Joe is Regulatory Compliance Counsel for Michelle and Associates. I am now doing a lot of Second Amendment litigation and not as much of the nuts and bolts, detailed regulatory compliance work that I used to do. So Joe is really the guy up to speed on that, and who really is on top of it. And so he's going to take it from here.
Okay. Well, as you see in that slide, these are the two topics that we're going to discuss today. These bills passed and were signed towards the end of July. We're going to be talking about the other bills that were signed in July, as a couple of slides back said, tentatively this coming Wednesday, and then a week from this coming Wednesday. We'll talk about the other ones. Ammunition we'll talk about, and how that overlaps with the Newsom initiative, and then all of the other bills that were signed and put into law just this last July. We'll be discussing those as well, and when those go into effect, and all the other fun and exciting stuff having to do with those. But for today, and for purposes of this lecture only, we'll be talking about the new quote-unquote assault weapon bills, which basically are identical, and change the definition of what is an assault weapon in California next year, and what people will have to do in order to be able to lawfully possess those firearms. And then, since there is some overlap with the assault weapon bills, with the so-called ghost gun bills, we'll be discussing, we'll be discussing that one as well. And let's get my mouse on the arrow so I can advance the slides myself. Legal disclaimer. I'm a lawyer. We're talking about legal things. Naturally, we'll talk about disclaimer. Keep in mind that this is not set in stone as of yet. Our friends up in Sacramento can still modify, change things potentially this year. We saw them suspend rules for the introduction of a number of these bills this summer. There's the potential of that. There's also, of course, future potential of them changing these laws next year, the year after that, the year after that. So always keep in mind that the things you know to be the law or have been the law for as long as you can remember are always subject to change, either by the legislature or by the court. And in particular, especially for some of these laws we'll be talking about today, California Department of Justice will need to come up with regulations with respect to a number of these bills of how you register your assault weapons and how you go about the process of getting serial numbers for your so-called ghost guns, and all of that stuff. So there will be changes to these laws regardless of what I discuss today. So always keep that in mind for purposes of what I'm saying here today. And then also, as Chuck alluded to already, I'm going to give you an overview. It's going to be a pretty darn detailed overview, but it's going to be an overview nonetheless. Always check the law yourself to confirm. Talk to an attorney who knows California gun laws and you have specific questions in mind. And of course, the best resource I can think of not because my name's also on the cover, but nevertheless, Chuck's book, California Gun Laws, all of these laws I'll be talking about today will be discussed in great detail in the 4th edition of that book. And like Chuck said before, if you order or pre-order that through the CRPA, you will get our full-blown analysis of all of these laws sent to you before you get the book. And then all of that stuff will also be in the book when it comes out in November. Fingers crossed November, potentially early December. We'll see. I noticed a lot more people have joined the webinar since I last spoke, and have a number of people with raised hands. I'll mention this a couple of times so the people who heard me before bear with me. But if you have questions, put them into the chat box. I'm not going to be able to address all the questions and concerns today. Nevertheless, we will go over all these questions. Myself and Ben will be answering a number of them. And then either through signing up with your email address or through the CRPA, we will be providing the answers to some of the most frequently asked questions. So I appreciate all the hands and all the comments, but please throw them into the chat box. Ben will try to review some of them as I go along and throw them to me from time to time. If not, and there's no way I'm going to be able to get to them all today, but nevertheless, we'll try to compile them, go over the most frequently asked ones within the next coming weeks. And so the assault weapon bills, as I mentioned, there were 2, and they basically do identically the same thing. Also, while they were signed earlier this summer, they don't come into effect, quote unquote, until January 1st, 2017. And basically what these bills do, they revise the current definition of what is an assault weapon, add a definition for what constitutes a fixed magazine, cause those firearms that now become or considered assault weapons to be restricted with respect to their activities and the buying and selling of those as of January 1st, 2017. And those newly designated quote-unquote assault weapons, if they're possessed prior to January 1st, 2017, will need to be registered. If I'm saying July, I really do mean January 1st, 2017. Those firearms will need to be registered before January 1st, 2018. And keep in mind, like I mentioned already once before this, these new firearms will be considered quote-unquote assault weapons. And so if you want to import or deal in these firearms after January 1st, 2017, you're going to need a California Dangerous Weapons Permit. And so before I talk about what the laws or the bills changed, let me first address what remains the same. You still have the make, model, ban list. And so that list that compiles the Penal Code and the Code of Regulations make, model, restricted list for assault weapons, that remains unchanged. Also, if you have a semi-automatic centerfire rifle with a fixed, quote-unquote fixed, magazine capable of accepting more than 10 rounds, that's going to still be an assault weapon. Your semi-automatic centerfire rifle that has an overall length of less than 30 inches, still going to be an assault weapon. Pistols with fixed mags that can accept more than 10 rounds, still an assault weapon. And the shotguns, as they're currently defined as assault weapons, those haven't changed. And so your semi-automatic shotguns with both of the following, the folding collapsible stock and the pistol grip, the thumb hole stock, and the vertical hand grip are going to be considered assault weapons. Semi-automatic shotguns with the ability to accept a detachable magazine, that language is unchanged as a result of this bill. And so as a result, those still be considered assault weapons. And then last but not least, any shotgun with a revolving cylinder, in other words, your street sweepers, still going to be considered an assault weapon under these new laws. What's been changed? Well, currently, as the law is current in California, you still have the restriction on semi-automatic centerfire rifles that have the capacity to accept a detachable magazine and one additional prohibiting feature, like your pistol grips or your forward pistol grips, your collapsible stocks or your flash suppressors. Same thing for your semi-automatic pistols. If the semi-automatic pistol has the capacity to accept a detachable magazine and one of those mean, nasty, scary features like a forward pistol grip or the capacity to accept a detachable magazine outside of the pistol grip or a threaded barrel, those are still considered assault weapons and will be considered assault weapons up to January 1st, 2017. However, at that time, the definition and these definitions will be broadened. And so at that point, you have the other half at the bottom of the slide to say that a semi-automatic centerfire rifle that does not have a fixed magazine and one of those mean, nasty features will be considered an assault weapon, and any semi-automatic pistol that does not have a quote-unquote fixed magazine, and again, any one of those mean, nasty features, will be considered an assault weapon. And so basically what this is going to boil down to, and the intent behind our so-called friends up in Sacramento, is to reclassify what meets the definition of assault weapon to include firearms that have devices commonly referred to as the bullet button or the magazine lock. Those firearms will be classified as of January 1st, 2017 as quote-unquote assault weapons. And I use the term fixed magazine for purposes of these rifles and pistols, and I'll advance it to that slide. What does a fixed magazine mean? Well, as a result of these bills, a fixed magazine means an ammunition feeding device contained in or permanently attached to a firearm in such a manner that the device cannot be removed without the disassembly of the firearm action. What exactly that means, I don't necessarily know for sure, but nevertheless, that is the new definition of what is a fixed magazine. And so what we're going to be dealing with is partly some confusion, no doubt, in what that phrase is going to mean, specifically what is the disassembly of the firearm action, and what is going to be required to either comply with that restriction and or modify the firearm so you can have one that is California compliant. But nevertheless, backing up a slide that I jumped over quickly, what's not going to be affected by these new restrictions, again, we don't talk about shotguns because shotguns weren't covered on these modifications, so your your shotguns will generally not be affected by this new redefinition unless they meet the definition of assault weapon currently. Rimfire rifles, because it requires the rifle to be center fire. Non-semi-automatic handguns, obviously, because in order to be an assault weapon, the firearm has to be a handgun. It has to be semi-automatic. And this would include your conventional semi-automatic pistols, your 1911 style pistols should not be affected at all by this new redefinition unless they have something scary on it, like a threaded barrel, because that just scares everybody. And so what do these new restrictions do? After January 1st, 2017, if you have a firearm that meets the definition of an assault weapon, you're not going to be able to, barring a very limited exception that I'm going to be talking about in a second, possess, manufacture, distribute, transport, import for sale, keep off or expose for sale, give and lend the assault weapon. That firearm with the bullet button, if it's not been modified, you're going to be restricted on those activities. Dealers who, as of December 31st of this year, have firearms that have bullet buttons on them and are still on their shelves, as of January 1st, 2017, will be technically violating the law if they still continue to offer and expose those for sale. If you decide to acquire or somehow acquire and move into the state with a firearm with a bullet button on it after January 1st, 2017, you yourself will be in violation of the California law because you'll be importing an assault weapon. Keeping in mind that for a lot of these violations, it's punishable as a felony or a misdemeanor, potentially an infraction, depending on the type of firearm when you possessed it and whether or not you failed to register it. And again, I'll be talking about that here pretty soon. But nevertheless, there's those restrictions involved. But there is an exception, like I mentioned, to the possession of a firearm that will be considered an assault weapon next year. So if you're in possession of a firearm that has a bullet button on it and it's otherwise lawful for you to possess, and I emphasize that because there's a lot of confusion with respect to people believing that this is somehow some kind of amnesty, and if they've had a Colt Sporter in their closet for all of these last years, they'll be able to whip that sucker out, register it, and go ahead and possess it lawfully at the range or wherever else have you. It's not going to do that because you could not have lawfully possessed that firearm up to and through January 1st of 2017. However, if you possess a bullet-buttoned firearm that is otherwise legal, at least right now, for you to lawfully possess, you'll be able to continue to possess that firearm into 2017, provided, as you see the last bullet on that slide, you register that firearm by January 1st, 2018. So if you're in possession of a firearm right now that is otherwise legal for you to possess right now because you have a bullet button on it or you acquired it and you put it together and it's a California compliant legal firearm under the current laws, you may continue to possess that firearm into next year, provided then sometime during next year you register the firearm with the California Department of Justice. And I'll talk about registration here in a bit. And as I mentioned before, you need to possess it prior to January 1st, 2017, which is why I mentioned earlier that if you went out of state and somehow was able to legally acquire that firearm and bring it into California after January 1st, 2017, or you put together a firearm after January 1st, 2017 that meets the new definition of assault weapon, that would be illegal activity. You need to possess the firearm that will meet the definition of an assault weapon next year, now, and before the turn of the year, which is why I say in this slide, if you want to purchase one of these firearms from a dealer, you should do so, and you should fill out the DROS paperwork no later than December 21st of this year, because remember, unless you're exempt from the 10-day requirement, it's required that a dealer process and take 10 days before transferring you the firearm. Well, hopefully that lawsuit is successful. That's challenging that, but for right now, this is what California law is. And specifically, if you want to acquire or have a firearm that meets the definition of an assault weapon next year, you will have to have acquired or possessed that firearm before January 1st, 2017. And so I know there will be a run on these guns. These things will probably be flying off the shelves the closer we get to December 31st, and then after that date, you're not going to be able to acquire these guns anymore. And so if you want to purchase one of these firearms and be in lawful possession of it, I would suggest that you do so now or as soon as possible, because as soon as you hit December 31st, that dealer is not going to be able to transfer you the firearm after January 1st. So if your background check gets delayed or there's a snafu with the paperwork and they have to take us a long time to run your background, and then as a result, that dealer will be prohibited from transferring you the firearm after January 1st, 2017. If you wanted to acquire these new so-called assault weapons after December 31st, you're going to be extremely limited. Retailers cannot purchase without a dangerous weapons permit, and then unless you are exempt from the assault weapon restriction or you have yourself a dangerous weapons permit, you're not going to be able to acquire these newly designated so-called assault weapons after December 31st, 2016. I'm sorry. And then last but not least, dealers, even if they have a dangerous weapons permit, will not be able to acquire or have individuals transfer to them firearms meeting the definition of an assault weapon unless those firearms are already registered. There's a case on this subject, and essentially what happened to Mr. Jackson was he had a dangerous weapons permit issued to him in the early 90s, and then a lot of people were selling him or transferring him their assault weapons during that time, but they had failed to register the guns under the original Roberti Ruse. DOJ found out about this and then decided to yank his dangerous weapons permit. And Mr. Jackson's response was natural. I've got a dangerous weapons permit. These things are assault weapons. I should be able to acquire and deal in them because I have a dangerous weapons permit. And the court basically said no. You can only do those. You can only acquire or purchase them from individuals who have lawfully registered the firearm, despite the fact that you have a dangerous weapons permit. Those firearms needed to be lawfully registered as well. So the registration requirements, they're touched on in the penal code and in the bills. However, the specifics and the where, for, whys, and hows, those need to be worked out by the California Department of Justice. And so what forms need to be filled out specifically, we don't know that yet because DOJ hasn't done that yet. Nevertheless, and there's no timetable for them to do that. DOJ, unfortunately for us, has had some problems implementing regulations timely. And if anybody's familiar with the DES system and when the FSC system went live through the computer, there were frequent problems with that. I would hope that they don't have similar problems with this, but that remains to be seen. But there is no timetable yet for when these regulations are going to come out, when the computer system is going to be completed in order for you to lawfully register your now deemed assault weapons online, which this is an online process that these bills prescribe. And then on top of that, we don't know when they're going to come out with the regulations with respect to this regulation or this registration process. All of this is pretty much in DOJ's court and remains to be seen exactly what's going to happen. But in order to register your assault weapon, you're going to have to describe the firearm specifically. And the question there is a pertinent one. Well, what if you created the firearm from an 80% receiver? I don't know. And I don't know if DOJ knows yet because the regulations for this registration process has not been implemented yet. Granted, as far as I'm aware, the most popular firearm created from an 80% receiver is usually an AR, and of course, hundreds, if not thousands, of lawful California firearm owners have assembled their firearm from an 80% receiver and lawfully enjoy possessing it and using it in California today. The process to register that firearm as an assault weapon come next year remains to be seen, and so we'll see what the requirements for those are. You'll have to say what the date was you acquired the firearm, and here's a little bit of a strange part. Name and address of the individual from whom or business from which the firearm was acquired. And again, you see another question of mine. Well, what if you can't remember or you can't recall from whom you received the firearm? Again, that is unclear. The code requires that information, but nevertheless, it would be something that's rather common that the person doesn't necessarily remember the wherefore, whys, and hows they acquired the firearm, nor are they required to keep paperwork or anything along those lines. Nevertheless, that is going to be one of the requirements for registration. And then on top of that, the personal information, your name, your address, your telephone number. Again, what if you don't have a telephone number? Don't know. DOJ hasn't come up with any regulations or any advice as of yet what to do in that situation, whether or not you can write down NA, whether or not you can say, I don't have one, and move on, whether or not DOJ will accept a registration without all of that information remains to be seen. And the last but not least, you're going to need to provide them your California driver's license or California identification card number. Specifically, California driver's license, California identification card number. This would seem to imply that people not from the great state couldn't register their firearms, but that also remains to be seen. And registration, like I mentioned before, will be online with a credit card. Unfortunately for us, DOJ is going to be required to create the website for this. Joint registration is an option. The code, as it's right now, allows for joint registration between family members residing in the same house. If you plan on registering an assault weapon in this fashion, I strongly advise you to register the firearm to everybody in your household who can lawfully possess firearms, and they're members of your family, because the problem potentially is this. If I, as a husband and my wife, have access to all our firearms, if I'm in possession of a firearm that meets an assault weapon next year, I then register the firearm, and I only register it in my name. And then I go to work. My wife, who's at home, who has access to a gun safe, would have then access to an assault weapon, and she would not be the registered owner of that assault weapon. She would technically be in violation of California law because she would then be in possession of an assault weapon and not have it registered to you. To her. So if you do reside with someone, husband, wife, children who are old enough to have assault weapons registered to them, because there's no registration for those under the age of 18, you're going to want to register all of the firearms to any of those adult members of your family within the household who would have access to the firearm to cover that. And then also the added benefit, if my wife wanted to go out shooting with that firearm, she wouldn't need me as the registered firearm owner to go with her. She would be able to go take that herself, and if she ever had any problems with law enforcement, she can say, nope, despite this firearm meets the definition of assault weapon, here's my registration for it. So you want to give me my ticket for speeding and I can go home? And she can go out her merry way. There's a lot of questions and concerns about gun trusts. As you see on that slide, no gun trusts. California law, specifically as it relates to assault weapons, requires the firearm to be registered to a person. A person in this context, as it's defined under current California law, is an individual. So in this instance, you're not going to be able to register an assault weapon to a gun trust and then be able to have that firearm possessed or passed down to people as a result of that trust, because the problem is going to be this, much like the situation with my wife. If I register the firearm in my name or the trust's name and somebody is found in possession of that firearm, and when law enforcement runs the background check of that firearm through the automated firearm system, and they are not the registered owner or registered possessor of that firearm, they will probably get arrested. And law enforcement is not going to want to hear about how whatever attorney sold you on the gun trust told you that you should be perfectly fine because the firearm's in a trust. The officer is going to look you up in the automated firearm system. If you're not the registered owner of that firearm, you're going to have some explaining to do, or potentially your attorney or public defender is going to have some explaining to do in the context of a prohibited possession of a firearm that meets the definition of an assault weapon. Last but not least, how much is it going to cost you? It's going to be a maximum of $15 per person to register the firearms, but that remains to be seen, because while it's a maximum, it's going to be required to be determined by DOJ to cover the cost of this registration process, and that remains to be seen. Ultimately, and probably, it'll be the full $15 because, well, heck, DOJ doesn't pass up a cost that they can't hoist upon the California consumer, but nevertheless, it'll probably be at full $15. Now, there were questions before I noticed in the chat concerning aftermarket modifications of these firearms, and specifically the MR2, the AR Maglock, the bullet button reloaded. All of these types of devices operate on the same function, specifically to the AR platform, in that you pivot the upper receiver up on the forward takedown pin, and then at that point are able to depress the magazine releasing the magazine. In theory, that is disassembling or the action of the firearm, but that will remain to be seen whether or not that activity constitutes the disassembly of the action. But that's the theory that those devices work under. Another device available that I've seen potentially as a workaround is the Franklin DFM magazine. Works similar on the principle that you would pivot up or remove the upper receiver of an AR platform and then install the magazine through the top portion of the magazine well, whereas in most magazines are loaded or inserted into the firearm through the lower portion of the magazine well, and in sliding in through the upper portion of the magazine well, once the upper receiver is reattached down to the lower, you're not able to pull the magazine out. It's basically in there and stuck in there unless you pivot or remove the upper receiver and then pull the magazine up and out through the top of the magazine well. There's that one. I've seen a lot of people suggesting permanently affixing their magazine to the firearm. That should work as well, either by pinning, gluing, welding, or Loctiting that magazine in, provided it's a permanent situation. That should work for purposes of this. And then last but not least, going featureless is an option, keeping in mind that these new definitions or redefinitions of quote-unquote assault weapons are still contingent on the firearm having those evil, horrible features, like for rifles, the pistol grip or the flash suppressor or the forward pistol grip. If your firearm doesn't have any of those so-called evil features, if it's still a semi-automatic centerfire and does not have a fixed magazine, it will not meet the definition of assault weapon for that specific definition because it doesn't have the evil so-called prohibited features. And so a featureless build remains an option.
So, Joe, let me just chip in here for a second. I want everybody to understand, and as far as NRA and CRPA are concerned, all of the aftermarket products that require the disassembly of the action because it swings forward on the pivot, the forward pivot, the receiver, the upper swings up away from the lower. All of those things satisfy the law, the statutes. There may have to be fights with DOJ because they may try and interpret the law narrowly, but the law does not say what they may want it to say. We've had this fight with DOJ as a regulatory agency continuously for probably over 20 years now, and we've often been able to stop them from trying to expand the definitions through policies, also known as underground regulations or adopted regulations. So that's where I definitely see there may be some litigation. A lot of folks are asking about lawsuits here, and we will definitely be, the NRA and CRPA will be filing legal challenges to every one of these laws that can be challenged, and that includes when the laws are applied or interpreted by DOJ. I expect there will probably be multiple challenges to the way DOJ handles that if they are influenced by politics rather than common sense. And with Kamala Harris at the helm, you can pretty much assume they will be influenced by politics. That's been their MO so far. They aren't putting the priority on issuing licenses or doing background checks for CWs or for dangerous weapon permits. They aren't putting the priority on getting the automated firearm system database, which tracks registered firearms. That's riddled with errors. So is the criminal history database. I mean, bottom line is they don't want to do the things that really they're supposed to be doing to manage gun registration databases and licenses to sell firearms or carry firearms. They would rather be doing things that get Kamala Harris's name in the papers that she can issue press releases about. And with that kind of an attitude, you have to expect that they're not going to want to accept some of these aftermarket products as bringing a firearm out from under the definition of a so-called assault weapon. That said, what you should come away from this with is that there are multiple ways to get an AR and an AK without having to register it as an assault weapon. So you can buy something before the end of the year, or if you already have it with the bullet button on it, you can register it, or you can reconfigure it to bring it out from under the definition of an assault weapon by going featureless, which means using a Monster Man grip or the other aftermarket products that bring the actual features out from under the definition of pistol grip or whatever, or by using one of these aftermarket products. But the safe thing to do might be, especially if you bought the gun after, in the last couple of years since long guns have been registered. I mean, your long gun is registered already. This is what really kind of makes this sort of silly. All guns that were bought after, long guns even, that were bought after a few years ago are registered. So if you're now going to register it as an assault weapon, all you're really doing is registering it twice. And so we're looking at whether or not there's some potential litigation just surrounding that dual registration and the fees that they're charging on that. But anyway, come away from all this with you have a couple of options, and ARs and other similar rifles will still be available. They may just look a little funny, but they're still going to shoot after you do the modifications.
Okay.
Joe?
Well, thanks, Chuck. Yeah, I'm back. We got another poll question. Looks like everybody's pretty much chimed in on that. We're also pretty close and running up against time. And so, Ben, if you'd be so kind as to tally all of those and move us into the next poll question, that'd be greatly appreciated.
Yeah. So next poll question, have you donated to fight the Newsom initiative? So I'll give it a second here for everyone to submit their responses.
Okay, well, this one is up. I'll just mention this is the Newsom Prop 63. Newsom's running for governor, and that's what this is really all about. He's got a bunch of billionaire elite techie guys who are his sponsors, Sean Parker from Napster and some others. If you go to the Coalition for Civil Liberties website, you'll learn a lot more about this, but it should definitely be on your radar. We had to form a coalition. We had to form a PAC, basically, a political action committee, and there are campaign finance limitations on how much NRA and CRPA and other groups can donate to fight this without possibly triggering disclosure requirements that of their members, which we're not about to do. So NRA, CRPA, GOC, other groups, Pink Pistols, and all the major sheriffs and law enforcement groups in the state have come out against this thing, and they're part of this coalition, which is formed to be the PAC, because the groups can't really lobby against this in their own names. But take a look there and be aware of what that would do. And if you have a few shekels laying around, we'd put them to good use.
Yeah, so it looks like we have not a lot of people who have donated, but as Chuck said, get out there and donate. So throw it back over to Joe.
Okay, yeah, and then moving over to the summary of basically everything I discussed for the assault weapons, and don't go anywhere, guys. We've just got ghost guns after this. What does it mean? If you want to be in possession of a firearm meeting the definition of an assault weapon come next year, do so, I would suggest now. Go visit your local firearm dealer. Go visit a Turner's. They've got these firearms available for sale. I fully expect there to be a run on these firearms, as you often have in a case where the government's trying to ban something at the end of 1 year. So if you want to do so, I would suggest doing that now as opposed to later. And like I said before, if you do wait, just keep in mind that you have to be in possession of that firearm prior to January 1st of next year. And so if you decide to wait until the after Christmas sale, you're going to be too late, because you have that 10-day wait, and as most people do, to acquire the firearm. And so if you wait that long, the dealer's not going to be able to hand you the firearm after January 1st, 2017. You need to be in possession of that firearm that meets the new definition of an assault weapon. And moving on to the so-called ghost gun bill. It did a couple of things, and we'll discuss both of them here, but it's probably a good idea to either define what is going to be restricted or what the new definitions are, and specifically what is not or what is going to be considered a quote-unquote firearm for purposes of this definition. And then we'll talk about later on some of the exceptions to these two new requirements for ghost guns as well. And as it says up there, the manufacturing or assembling, which I'll talk about here in a bit, it means to fabricate or construct a firearm or fit together the component parts of the firearm to construct a firearm. And so basically if you're putting the thing together or you're fabricating it, that will be considered manufacturing and assembling for what I'm going to be talking about here in a second. Also keep in mind that for purposes of these two laws, a frame or receiver is considered a quote-unquote firearm, despite the fact that it's just one component part and can't do anything other than weigh down some papers on your desk. Without all the other parts of it, that frame or receiver, that part that's classified as the frame or receiver of a firearm, is considered a firearm for purposes of these bills. However, an antique firearm is not considered a firearm for purposes of these sections. We're not going to be dealing too much or be overly concerned about those prior to 1898s or replicas thereof, but keep in mind your muzzle loading firearms are not going to be considered a firearm for purposes of the ghost gun bill. So just bear with that. So if you have the black powder muzzle loaders, those won't be considered. If you like to make black powder muzzle loaders that meet the definition of antique, those won't be covered in these laws. But basically what the ghost gun bill does is two things. You're going to have to ask so-called permission from DOJ prior to making your own firearm. And then if you have made your own firearm, you will need to ask DOJ for serial numbers and provide them information concerning the firearm you've already made. So as of July 1st, 2018, if you want to, and there's those two words again, manufacture or assemble a firearm, you will need to apply for with the California Department of Justice to get the serial number, and I'll talk about that process here in a second. And then within 10 days of manufacturing or assembling the firearm, you're going to need to slap that serial number that DOJ provides you on it. And the way you do that is you're going to have to abide by the requirements that full-blown manufacturers have to abide by when engraving or stamping their firearms. And then once you do that as well, you're going to have to let DOJ know that you did that. And so not only will you have to contact DOJ to ask them for the serial number and provide them information about this process, once you make the firearm, Within 10 days of making it, you're going to need to slap that serial number onto it, and then after that, you're going to need to let DOJ know, hey, I've done this, I've completed the firearm, look at me, and then last but not least, provide them that information. And then also, like I hinted at before, the firearms without serial numbers, and there are some exceptions to both of these processes, and I'll talk about that here in a second as well. However, if the firearm doesn't have a serial number on it, and if you own the firearm as of July 1st, 2018, then you're going to need to place one of DOJ's serial numbers on it prior to January 1st, 2019. And I see a lot of questions flying through here, and I'll address those, or at least I hopefully address some of those here in the ensuing slides. But nevertheless, if you possess a firearm without the serial number on it, and there are some exceptions to this, as of July 1st, 2018, you're going to have to ask DOJ for that serial number, and so you're going to have to apply to DOJ for that unique serial number. Within 10 days of receiving the number from DOJ, slap that number onto the firearm, again, according to manufacturer specifics or specifications as they're outlined in federal law, and then sure enough, just like before, circle back around to DOJ and say, hey, I've put the serial number onto the firearm, and therefore I've completed that process. And like I mentioned before, for both applying for the serial number from DOJ and when you want to manufacture your firearm after July 1st, 2018, or if you're in your possession of a firearm after July 1st, 2018, the application process with DOJ to get that serial number is going to be identical. You're going to have to do and fill out a personal firearms eligibility check. You're going to have to present proof of age of identity. That's using your California driver's license and ID card again. If you're in possession of a long gun, you can register it 18 years of age or older. If the firearm is a handgun, you're going to need to be 21. Describe the firearm, and then last but not least, you're going to have, or at least show that you have a firearm safety certificate or still an unexpired handgun safety certificate, which we're getting up in age for the handgun safety certificates, but nevertheless, that will be an exception as well. DOJ is going to have to process these things, for DOJ at least, relatively quickly. And then last but not least, how much they're going to charge, that remains to be seen. DOJ is going to have to figure that out and let everybody know through the regulations they're going to adopt. It will be also, under these laws, illegal for you to assist a person prohibited from possessing firearms in the process of manufacturing or assembling them. And if you violate any of these laws, if you possess the firearm without slapping the serial number on it after July 1st, 2017, if you want to manufacture that a firearm on or after July 1st, did I say 17? I'm sorry if I did. These are all 2018. So if you want to manufacture a firearm after July 1st, 2018, or if you assist somebody prohibited in the process of manufacturing or assembling these firearms, all of these will be misdemeanors. If it's a handgun, you could be subject to up to a year in county jail and or a $1,000 fine. For long guns, it's 6 months and or a $1,000 fine. Also keeping in mind that because these will be firearm convictions, you also have the potential of the court or the prosecutor insisting on firearm restricting probation terms also as a result. However, all of that stuff I mentioned before doesn't apply to the following. If the firearm already has a serial number assigned to it, pursuant to the Penal Code or as required under the Gun Control Act, you're good to go. So if you purchase a receiver from a licensed firearm dealer and go through the background check process, and that receiver is a fully functioning receiver, it's not an 80%, but a fully functioning receiver, that receiver should already have all of the pertinent information on it, and as a result of you purchasing it, it'll be registered to you. You won't need to, if you build up or you assemble a firearm based on that receiver, you won't need to go through this process. Also, you have your firearms made or assembled prior to December 16th, 1968. There are handguns. The one I highlight here is the thing to look out for because this will potentially cover a lot of people. Firearms that are already entered and accepted into the centralized registry prior to July 1st, 2018, as owned by a specific individual or entity with a distinguishing mark or identification attached to it already will not need to go through this process. And I'll talk about that a little bit further here in a second. Then, of course, NFA firearms, your machine guns, your short barrel rifles and shotguns, silencers, destructive devices registered with the federal government, those should be all good to go. And then last but not least, your curios, relics, and antiques as defined by federal law. Those won't be required to go through this process. But like I mentioned before, if the firearm is already in the centralized registry and registered to you prior to July 1st, 2018, there's nothing further for you to do. And California law currently helps you out with respect to this, because any person can place or stamp on any pistol or revolver or any other firearm, provided it doesn't change, alter, or remove the identifying information. You can put that on your firearm right now. You are also allowed to register your firearms right now. And so if you were to, if you've made an 80% firearm, or made a firearm, I should say, instead, from an 80% receiver, if you were to go about the process and register that firearm right now, you would not have to, come July 1st, 2018, register them through the process as outlined in this bill, and specifically meet all of the engraving and stamping requirements that are in the bill, because your firearm will be already registered to you. And so there's a form for you to voluntarily register your firearm. Once DOJ accepts that registration and puts that firearm into the system, all of the stuff I mentioned before about you having made your firearm and stamp it and ask DOJ for specific numbers with respect to the identifying information for the firearm, that won't apply. So if you go about the process now, you can pretty much circumvent the stamping process. However, after July 1st, 2018, if you're going to want to make your firearm from an 80% or from raw materials, then at that point, I'm sorry to say, you're going to have to abide by the DOJ requirements in assembling that firearm, and then, of course, requesting for the identifying information. Also, if you're registering assault weapon, and like I mentioned before, a lot of the firearms I'm familiar with that individuals choose to make for themselves come from the AR platform. And as of next year, a lot of these firearms are going to meet the definition of so-called assault weapons. However, if you were to register those firearms then as quote-unquote assault weapons, that should also be sufficient for purposes of this bill, because that firearm, or now deemed by California an assault weapon, will be registered to you in the centralized registry. There should be no requirement that you to move forward with the registration process, as I've previously discussed. And so there are a couple of workarounds, so to speak, without having to go through the process of reaching out to DOJ, getting the serial number, and then specifically stamping or etching that firearm pursuant to federal guidelines, and the stamping and etching of the firearm, and then telling DOJ that you've done that. And so you do have a couple of options for purposes of these laws with respect to firearms you currently own, and not having to go through that full rigmarole. What does this ultimately mean? I see a substantial issue with respect to the 80% receiver market. Of course, a lot of the people who manufacture or put together their firearms do so because they're extending their Second Amendment rights and their ability to make their own firearms for themselves, which both state and federal law allow you to do, provided the firearm is not an illegal for one for you to possess. However, after July 1st, 2018, I see there's probably a decline in the enthusiasm surrounding making firearms from 80% receivers. On top of that, like I mentioned before, you might want to consider, if you've made your own firearm from an 80% or raw materials, you should be able to go through the process and register that firearm now and not have to worry about, again, contacting DOJ for this number, slapping the number onto it, and then recontacting DOJ saying that you do it. And then last but not least, if you're going to so-called fly under the radar or try to see how far you can get, just be aware that failure to abide by these requirements would be considered a misdemeanor, and despite it being a misdemeanor, courts and prosecutors quite often will look for, and in a firearm case, seek restrictions with respect to firearm ownership as a result of conviction. Touching on the deadlines, your last day to apply to purchase a firearm that's going to meet the definition of an assault weapon would be December 21st of this year, keeping in mind you got that 10-day wait to contest with. If you're going to want to possess and own a firearm that meets the definition, or I should say the new definition of assault weapons, you're going to have to possess that firearm no later than December 31st, 2016, because the definition of assault weapon will go into effect on January 1st, 2017. So that firearm will now meet the definition of an assault weapon come the turn of the year. And then your last day to register these newly designated assault weapons will be December 31st, 2017. And then for the ghost guns, you're going to need to seek permission to manufacture or assemble these firearms on or after July 1st, 2018. And then the last day for you to register the firearm that does not have an identifying mark, provided you possess it before July 1st, 2018, will be December 31st, 2018. Come January 1st, 2019, if you are in possession of a firearm that doesn't have an identifying mark, isn't previously registered to you, and for the reasons, or the firearm meets the definition of one of those that doesn't need an identifying mark, it will be a violation of California law for you to continue to possess those. The resources, the bills are still available on the state legislative website. The two assault weapon bills, AB 1135 and then SB 880 are there. You can look over the text of those yourself. Like I said, they will also be discussed in great detail in the California Gun Laws book, the 4th edition, which we're going to be putting out this coming November, early December. And if you pre-order through the CRPA, you will get our office's full-blown analysis of all of these laws that passed in early July. Not only these, but the upcoming lecture we'll be doing on ammunition, and in addition to that, last but not least, the lecture on the loan, theft loss reporting, and of course I'm missing one, large capacity magazines. And so we'll be discussing all of those in upcoming webinars. And then of course the Ghost Gun Bill, AB 857, that is also on the legislative website. And that's it. Thank you all for attending. I see a number of hands still raised. I know people came in late, and so I will circle back around to that. If you have questions, then we'll keep the chat room open after I am done with all of this.
Joe, let me jump in here just for a minute. I'm reviewing some of these questions. There's a couple of things that I think have general interest, and we've still got a lot of folks on the line, and so we're happy to spend a little extra time if you guys don't mind staying on the line. So somebody asked what a dangerous weapons permit was. There's a bunch of different permits for selling assault weapons or selling large 10-plus round magazines, that kind of thing. There's a number of different special permits available through the DOJ. The biggest question here, Joe, and I'm going to let you answer this while I try and sort some of these questions, is after you register the firearm as an assault weapon, if it's a bullet button firearm or the mag-lock firearm initially, can you then remove the bullet button?
That remains to be seen. My position is that, and it's very similar to the changes in the law as they related to the make model ban list, and then we got stuck with the Category 3 assault weapons, and basically what the Category 3 assault weapons are those featured assault weapons, the firearms that aren't on the list, but assault weapons that meet the definition, firearms that meet the definition of assault weapon. You were able to modify your make model assault weapons to add or remove features at will, because those make model assault weapons were already registered and already met the definition of assault weapon. And so they were firearms that were registered to you as assault weapons. And the requirement and the exception to the restriction on owning and possessing firearms that meet the definition of assault weapon for most people is that the firearm is registered to you as an assault weapon. So in this instance, in this situation, if you register your firearm with a bullet button as an assault weapon, you now have a registered assault weapon. A firearm with a bullet button attached to it or a magazine lock attached to it, or that has the capacity to accept a detachable magazine, those firearms will all be considered quote-unquote assault weapons. But in this instance, you will have a firearm registered to you as an assault weapon. So in that instance, you should be able to continue to possess it because, again, it is now registered to you as an assault weapon. You have an exception pursuant to the Penal Code to the restrictions on possessing firearms that meet the definition of assault weapon because it's now registered to you as an assault weapon.
So you should be able to, we'll have to see what DOJ, if they try and mess with this, but you should be able to register your firearm as an assault weapon and then remove the bullet button because either way it's still an assault weapon.
It's a registered assault weapon at that point. And to circle back around to Chuck addressing the dangerous weapons permit question, keep in mind that in order, much like an unfortunately, people acquiring for CCWs, California law requires you, in order to get a dangerous weapons permit, to have quote-unquote good cause. Good cause is very narrowly construed by the California Department of Justice and the California regulations relating to the application and your ability to acquire a dangerous weapons permit. And specifically, I'm stating this rather broadly, you basically have to be involved in the dealing with military or law enforcement of these firearms or doing research and manufacturing with respect to these firearms for sale potentially outside of the state. But nevertheless, this is not the type of permit everybody in the state is going to be able to get in and for themselves. You're going to have to be engaged in very specific and narrow occupations in order to be able to acquire and have a dangerous weapons permit. Last but not least, the entertainment industry is one, with Hollywood needing machine guns and short rifles and shotguns, and then, of course, assault weapons for purposes of their movie shoots. Being in the entertainment field also is usually a area that will allow people to acquire a dangerous weapons permit. And again, most people in the state of California are not going to have those ties to military law enforcement, manufacturing, research and development, and of course the entertainment industry to acquire a dangerous weapons permit.
We have another series of questions about co-registering assault weapons to multiple owners. Joe, you can elaborate if you need to, but I think the answer to this is anyone over 18 that's at your house, that's in your household, can be co-registered on an assault weapon. So I'm going to register my 18-year-old son on my AR, and then when I pass away, he will still have it. I'll have to think about whether I register my wife, but I'll put my son on there. And so I encourage everybody else to consider this as a possibility too. Get as many people on there. You know, what the government initially intended to do was try and wipe out assault weapons, so-called, in the state of California within one generation. Well, that hasn't worked very well. They started back in 1989, and now, here we are many years later, and we're going to be another generation now before these happen. And depending on what happens with the presidential race, there are a whole bunch of lawsuits queued up to protect these modern sporting rifles that are the most popular firearms in the country, and that should be protected by the Second Amendment. But if Hillary Clinton gets elected, she's going to stack that court, and with judges who are hostile and interpret the Heller case directly opposite of the way Justice Scalia intended, and we won't have much success in making those kinds of challenges. Anyway, you can co-register a firearm with other folks. There's a lot with up to over 18-year-olds in your house. There's a lot of people asking about taking a registered rifle in and out of the state of California. If you're a California resident but you have a place in Nevada to put a rifle and you don't want to register it, you can store it outside of the state of California, assuming it's legal in the state where you're storing it, and then you just can't bring it back into the state of California. There used to be a little cottage industry out in Nevada where gun stores would have a special room with everybody would have a gun safe, and they could put any guns they wanted in there, and they'd drive out to Nevada and shoot the guns and put them back in the gun safe. They rented a little space from the gun store's warehouse and then leave it out of state permanently. Now, if it's registered, you can bring it in and out of the state without a problem. Carry your registration paperwork. A lot of folks were asking about whether or not this webinar is going to be posted someplace or they can get a copy of the slides. I mentioned at the beginning, but let me reiterate, the CRPA will have this webinar and all the other webinars. We're going to have a full library of all these webinars on the CRPA website. This is the first one we've done. We had 3,000 people register for this, so some of you folks, if you had technical difficulties, I appreciate your patience, but we will have a library of these on CRPA's website. At some point, we may make it a member benefit. For now, at least the first few, they're just free, and you don't necessarily have to be a CRPA member to watch, but because we want to get these questions answered and we want to get people informed and engaged. But we won't be making the webinar separately available. You'll be able to get it through the CRPA website. Just a quick word on the Veto Armageddon effort. There's a lot of folks asking about that. That's really beyond the scope of this webinar, but I know lots of people are asking. The Veto Gunmageddon Facebook page has a lot of information about where you can get these petitions and sign them. I'd encourage everybody to learn about that and sign the petitions. CRPA and NRA have those at their tables at the events throughout the state. CRPAs in Orange County, I believe they have petitions available if you want to get them. Most gun retailers have them available. I'm not sure whether or not there's a real good chance of success of this, but that's really beyond the scope of this. We may do another webinar just on this effort. But in the meantime, go sign it. I mean, there's no reason to not be engaged. What CRPA and NRA are working very hard to do is get all gun owners engaged, informed and engaged, voting, participating, and telling the politicians how mad they are, because really every gun owner has a right to be furious about the way that we're being treated, the whole campaign of shame that's being levied on us by the gun ban lobby, and all the lies that are being told about gun owners and the NRA and CRPA. It's just kind of shocking. There's some questions on there about folks don't understand what exactly NRA and CRPA do in California. NRA has the Office of the Executive Vice President has 3 employees working full-time in California. ILA has another full-time lobbyist up in Sacramento. That's the NRA Institute for Legislative Action. And ever since, actually for a lot longer than this, but in February, Chris Cox gave a speech at the CRPA banquet and said that every penny raised from California by the NRA will be spent back in California. That's really not news, because that's been the case for probably the 20 years that I've been working for the NRA. Obviously, any money that CRPA raises is spent back in California. CRPA now has about 13 employees in Fullerton, California, and 1 lobbyist in Sacramento working with the ILA lobbyist. So there's a structure set up there. Also, the NRA has NRA local members councils throughout the state that you can get information if you search that term. And NRA Members Councils of California has a Facebook page. And CRPA is building a volunteer corps. The idea here is we really need to build our grassroots. John Lott just did a great article about the lies. It ran in National Review about the lies that are being told about the NRA as, buying off politicians and spending all kinds of money on lobbying. Michael Bloomberg, who is the leading anti-gun guy, makes more in a year than the NRA has raised in donations since it's been in existence over 100 years ago. That guy drops $10 million checks into races all the time. And the only reason the NRA wins, NRA is scraping to put together $50, $60, $70 million to influence the presidential race. The only reason the NRA wins is because the grassroots activism and the members being vocal. So in California, again, I have said we have 6 to 10 million gun owners. If just a small portion of them registered to vote, we could make a difference in this state. Joe, there's some questions about constructive possession issues. What if you possess these parts? You want to talk about some of that so people don't get in trouble by keeping their parts too close to the registered gun?
Okay, I don't necessarily see what those are, but I can talk about that with respect to possession of, I'm assuming it has to do with assault weapons, and then whether or not you're in possession of the parts that, if assembled, would meet the definition of assault weapon come
Correct.
January 1st, 2017. You want to be very careful.
Okay, go ahead, Joe.
Yeah, you want to be very careful about that practice, because while a firearm, if it's in pieces or doesn't actually have all of the parts in order to be considered an assault weapon because you've taken those parts off or you've taken the firearm apart, my argument as a criminal defense attorney would be that that firearm does not meet the definition of an assault weapon because it either doesn't have the prerequisite and required features to meet the definition of assault weapon, or if it's completely taken apart, it's not functioning, and so therefore not semi-automatic, and most certainly doesn't have all of those parts required for it to meet the definition. That all being said, and however, law enforcement and specifically prosecutors are very clever in what they do, and there's a case called People v. Wynn. And basically what Mr. Wynn got in trouble for was he possessed not even complete parts, but he possessed a number of parts, some of them still needed machining, that if put together would potentially meet the definition of an assault weapon. And he essentially told law enforcement, look at these great parts I have, and I learned this on the internet, and if I put all these all these parts together, I'll have me a quote-unquote AK-47. Well, originally, and this case came out of Orange County, the Orange County District Attorney's Office tried to charge him with manufacturing and possession of an assault weapon. And at preliminary hearing, they realized that they couldn't charge him with that because they didn't have a complete assault weapon. And so essentially what they did was they flipped the script on poor Mr. Wynn and charged him with attempted possession and attempted manufacturing of an assault weapon. And they got a conviction because based on his possession of all of the parts that, if completed and put together, would meet the definition of an assault weapon, and his statements that he was going to be putting together an AK, quote-unquote, 47, that was sufficient to show that he had the intent to make a firearm that would meet the definition of an assault weapon. And but for law enforcement showing up and stopping that, it appeared that he was going to follow through on his stated intent. That is pretty much textbook, the requirements to show attempted anything. He had the ability to do so, he had the intent to do so, and but for law enforcement stepping in, he probably would have done so. And so at that point, he got convicted of attempted manufacturing or attempted possession. So in situations like this, and circling back around to the question at hand, if you're in possession of all of the parts that in theory could be then assembled to complete an assault weapon, first of all, you should not be discussing anything with law enforcement without an attorney being present. So anything law enforcement wants to ask you about your guns and what you intend to do with them, I strongly advise that you don't answer any of those questions without an attorney being present, and you tell law enforcement that. And then last but not least, if you're going to possess all of those parts, regardless, have in front of you or have with those parts parts that would allow you to make a California compliant firearm. One of the things the attorneys for Mr. Wynn tried to do or tried to show that is Mr. Wynn could have gone out and purchased a bullet button or something else that would have caused the firearm, if fully assembled with that part, to be a California compliant firearm. That argument, unfortunately, for Mr. Wynn didn't go very well because he didn't have any of that stuff, and the fact that he could potentially do that didn't fly too well with not only the trial court but the Court of Appeals. So in that situation, I would certainly suggest making sure you have the ability to complete a California compliant firearm, and of course do not discuss anything with respect to your supposed intent with regards to assembling or putting together that firearm. And then at that point, unfortunately, if you're in a position with law enforcement standing right there and looking at all the parts of your firearm that may be able to be assembled to be an assault weapon, that law enforcement officer is going to have to kind of make a decision on his or her own part and the wherefore, whys, and hows, and how to pursue or proceed with your case. And then that might be a situation where...
So shut up and call your lawyer. Don't make statements to the police. Keep your conspicuously protruding pistol grip, standard pistol grip, far separate from the rifle that has the Monster Man swayback grip on it, so that those two things aren't connected if you're doing something like that. But really, the sad thing about this is what these laws have made us come to. You can't be cooperative with police because the police have, in many instances, not always, but because the police have been politicized, and now they're like the gun cops. A lot of police don't like that. They don't appreciate that. You might get a break, but the safe thing to do is just not make any statements about the firearm and have the the registration paperwork there, or something that kind of shows that you've considered this and this gun is now reconfigured to not be an assault weapon. I'll mention that Ben, Joe, and I are in the process of finishing a second book called The Gun Owner's Guide to Police Encounters, because this has become such a big issue across the country, and especially now in California, but also in New York. You had the whole non-compliance issue there. And I respect folks who, just make a personal decision to not comply, but really, if you don't comply and you get caught, typically what they'll do is they'll file a felony charge against you, and then you have the sort of the devil's choice of, do you go to trial and try and hope for jury nullification, which is always a long shot, to beat the felony charge, or do you take some kind of a misdemeanor plea, which allows you to continue to own guns, because if you have that felony charge, obviously you're prohibited from owning guns for the rest of your life. So non-compliance is civil disobedience. Everybody has the right to do that, but you need to go into that with an open mind, understanding what the consequences and what the choice can be. There's some confusion out there about StopNewsom.com versus Stop the Ammo Grab or the Coalition for Civil Liberties. There are two PACs fighting Newsom. The NRA-CRPA PAC is the Coalition for Civil Liberties. That's at StopTheAmmoGrab.com if you want to know more about that. The StopNewsom.com effort, frankly, I'm not seeing them putting a lot of the money that they're raising into trying to influence voters. I see more ads to raise more money, but I'm not seeing enough effort to sway that swing vote, which is what the coalition's trying to do through some of the ads that they did on Facebook, the videos, the commercials that we've gotten some national attention for, and most importantly, all that police support, all those big police organizations that we've recruited to that cause. But look at both sides, make your own decision, but the NRA and CRPA are in the Coalition for Civil Liberties. I think that's about all. Some of you are saying you're having problems getting through on the CRPA site. That it may be overwhelmed because of the numbers.
We might have crashed it.
we might have. But if you can't get through, contact@crpa.org, and they will sort through all that. This has been a great beta test, really. I apologize if you've had technical difficulties on any of these websites or in listening to this webinar. We'll get all those kinks out. We're going to keep doing this. We're happy to provide this service. NRA and CRPA, as my clients, are thrilled to be able to offer this to folks. And really, there seems to be a pent-up demand, which we're going to now continue to try and serve by doing some more of these. So thank you, everybody, for coming, for attending, for listening. We still have almost 700 folks on here. We started with about 1,000. But I will do these for 50 people, or less, for crying out loud, if it helps. So, volunteer, donate if you can, join, and stay plugged in, stay involved, get vocal, and we'll see you at the next webinar, hopefully next week.
Yeah, this coming Wednesday is tentatively scheduled.
Watch your emails.
Yep.
Don't delete those as junk when you get stuff from us. Because we'll be telling you by email blast about when the next webinar is.
Yeah, that should be coming out. It should be this. Absolutely, no problem, Chuck. It should be this coming Wednesday. I know NRA did this great service by also advertising it, but CRPA did as well. And then which we'll be talking about ammo, the wherefore, whys, and hows that you're going to be stuck with acquiring ammo, the restrictions on bringing them into the state. We'll also discuss briefly the Newsom initiatives, ammo requirements and restrictions, and how those compare and contrast with what was passed this last July. That will be discussed on Wednesday, or at least tentatively for right now, scheduled for Wednesday. Check local listings. And then last but not least, a week from Wednesday, we'll be going over large cap mag, loaning, and theft loss, or false theft loss reporting the Wednesday after that, at least tentatively for right now. And those of you still online, feel free to continue to fill that comment box full of questions. And like we said before, we'll be going through those. please bear with us. It took us quite some time to answer the questions that we had last time, as they tend to be very good questions, very detailed, and take some time to go through. I would hope to have a turnaround on those within the next week. But to keep an eye out for the answers on those, we either post them on CRPA's website or Michelle & Associates website, and then potentially email them out to you for people who have signed up using a real email address. And as a result, I think that about does it. For me as well, I'll be going offline, but like I said, we'll keep the comment boxes open for you to go ahead and continue to ask questions. And then last but not least, all of this stuff will be covered in great detail in the upcoming book, California Gun Laws, written by Chuck and myself. And if you pre-order through CRPA, you get our office's full-blown 60-plus page analysis of all of these laws, the ammo bill, the assault weapon bill, the ghost gun bill, large cap mag, as well ahead of time, and then all of that information will also be in the 4th edition when it comes out in November. But that about does it to me. I hope to have you all back on Wednesday to hear our dulcet tones on ammunition, and that's about it for me. Take care, everybody. Bye.
Thank you. Please stand by.